Տարիների ընթացքում ձեռք եք բերում սեփականություն, կուտակում եք մեծ գումարներ, իսկ մտածել եք, թե ինչ է լինելու դրանց հետ ապագայում։ Լավագույն որակավորում ունեցող իրավաբան Մարիա Պրիմուշկոն իր բազմամյա հաջողակ փորձով կօգնի ձեզ ժառանգության փոխանցման, կտակ կազմելու եւ ձեր ունեցվածքն ապահով պահելու հարցում։ Estate planning, bankruptcy, personal injury եւ այլ իրավական հարցերով դիմեք MVP Law Group։ Ձեր ընտանիքի ապագան կախված է այսօրվա կայացրած որոշումից։ 818 788 7881
Good evening, dear friends. You're watching MVP Law Group show and its host and attorney, Maria Primushko. As you know, during our shows, we discuss very important legal issues that affect our communities. But today is a special program. Today we're live. We are ready to accept your calls. Hopefully you've seen the ads. You know that we're on the air and you can call us at any time and ask us questions. But also today we're going to talk, and today and throughout several next our programs, we're going to discuss the most frequent questions we receive throughout our programs. Almost every time after the show, we receive questions and messages on Instagram, on Facebook, to our office, directly to email address, or we receive calls to our office. So today we're going to talk about this, the most frequent questions that people usually ask. So you can call us, you can ask us questions too. It is live, we'll answer those questions, hopefully. So the phone number you can dial 844-404-0808. You're welcome. So we can start with the first question, and that was asked by Eleonora Akopian. How's my property transferred at death? Well, I know we spoke about it during our prior programs, so maybe I will reiterate myself. Maybe you've heard this information before, but I cannot stress enough how important to know and understand what's going on here in America, in California, because for our communities, Armenian community, my Russian community, for any people who came from former USSR, it is a very new concept on inheritance law, because we think differently. In our country's process of inheriting property was completely different, much easier and much straightforward. So the question by Eleonora, how is my property transferred at death? Well, as any attorney, I will tell you it depends. It depends on numerous issues. For example, we need to know how is title held to your property. And by property right now, Eleonora was referring to real estate, your house, your condo, your rental property, your dacha, your forest house. So how is title held? Do you own the property as a single owner? We discussed it during our prior programs. As a joint tenant with the right of survivorship, it belongs to LLC, etc. But from Eleonora, we found out that she owned it as her sole property. She was a sole owner of this property. So if a property owner passes and cannot and didn't prepare any documents advising, giving instructions who will receive the property, that means that's called living trust. That means that her heirs, her children, will have to petition the court and ask the court to transfer title from their mother's name to their name, because there are only two people exist who can transfer title. It's a property owner, him or herself, but in our scenario, that person passed, or probate judge. Probate judge is a judge of the probate court that administers inheritance issues and decides who and how receives the property. Also, if there was a will only merely gives an idea to judge who the owner wanted the property to go to. So there's still going to be a probate process. So there is only two ways, as I told you, at death to transfer property. If no documents created, then it goes through probate, through intestacy laws, and the judge decides who receives the property. And here in Los Angeles County, it can take, as I mentioned numerous times before, up to 2 years. And second, you can create a living trust. It's a document that we've discussed before, where you can create an agreement basically between yourself and yourself as a trustee, saying, hey, Eleonora, now I give you the property, you're now the trustee, please manage it, and I instruct you or my successor trustee, if I pass, if something happens to me, then the property goes to my son, let's say, or to my 2 kids 50-50. In this case, when everything is set up right, documents are signed properly, funding has been done, then the property will be transferred to your children with no hassle, no extra money spent, no time spent, without interference of any government agency, and without any noisy neighbors or friends or relatives knowing exactly how much you own, how many kids you have, if you have kids from prior marriage, what is your family dynamic, etc. So it is a very important question. And again, we're coming back to completely different system here, which each and every one of you have to be aware of. Please keep in mind, the purpose of this program is education. I'm giving you knowledge, and that unfortunately many people do not know about, they do not talk about it. And I'm not talking just about our communities, our Armenian community, because even Americans, you know, most of my clients are actually American regular people, clientele, and they also have no clue. They also don't know. The most they know usually is that, oh, I need a will. Nowadays, thank God, many people started thinking about creation of living trust and more sophisticated documents to protect themselves during life, during incapacity, and after passing, and protecting their families. As you know, motto of my firm is your future depends on the decisions you make today. So the purpose of this program is education. And now, so when you get the education, you have choice how to proceed. So let's go to the next question. We don't have any live calls yet. Svetlana Shikova, she asked, what happens if I die without a will? Well, it's a pretty similar question. If you die without a will, basically it means that no documents have been created, and it means that we have to go through probate court, her friends or her relatives, children, extended family, etc. For example, right now I'm handling a probate case where an older lady who had no children, no immediate family, passed away, and her cousin now handles the probate. And they were almost completely unaware about her whereabouts, what was happening until she passed. And now we know that it was her actual intention that she wanted to, because she didn't have her immediate family, no children, she wanted to devise most of her property. She wanted to donate to the charity, to the church she was going to. But, you see, since she didn't create any documents, now her extended family, 2 cousins who barely knew her, will receive her money. Good for them, I guess. And that's how the law goes, because if you don't create the plan, the government, the state will create already has a plan for you, because everything is set up, legislation was set up that appoints whoever is in line to receive the inheritance. So if you die without a will, you lose power, you lose control, you give it to the state to decide who gets what. And actually, in our scenario, it's a good scenario because the lady was alone, nobody has to fight. But when there are kids involved, especially minor children, if you die without a will, that is potentially can become a disaster. we can go to the next question. Gurgen Sargsyan asked the question, I heard that the estate tax will be repealed. Does this mean that I no longer need to prepare an estate plan? Well, first of all, what is estate tax? Estate tax is a tax on your estate, basically. But there are some limits. So government created a limit. Right now, it's a pretty high exemption. It is 11.5, a little more, $1 million exemption. So if you own the property under 11.5 million, you're not subject to estate tax. However, this tax at one point was only 600,000. Just think about it, 600,000. What's here in California can cost 600,000? Probably very mid-level house, right? And anything extra that you own will be taxed. And estate tax is pretty heavy. It is almost 50%. It's 40 some percent. So right now it's 11.5 million. So most of my clients, most of people here, unfortunately, do not have to worry about it. I mean, I wish all of you were millionaires and had to worry about it. But Biden administration, we've been waiting when they're going to reduce this estate tax exemption. And we're expecting it to be dropped either to 3.5 million or 5.5 million. Two numbers are going around in a community, attorneys community. So we're expecting this. And if it goes down to 3.5 million, again, what is 3.5 million here in California? Probably a couple of house and a half south of Ventura or in nice Glendale area. Stock accounts, rental properties, bank accounts. So if most people think that they don't have an estate is whatever you own. And the amount, it's very cumulative. You don't think about it, but if you count everything that you have, that is actually it comes down to pretty high amount. So think about it. And let's say it's 3.5, it comes down to 3.5 million, and your estate is 5 million. That means that 1.5 million is subject to estate tax. And that means that your kids will have to pay the government, the IRS, almost half of that 1.5 million. So you're just basically generously holding, keep saving money for the IRS in the future. So if you have any considerable estate, which right now I'm looking at 3.5, 4.5 million and over, I highly recommend you to speak with the trusted advisor, with an attorney, and see what options available for you to plan for that. To plan to save on taxes, because there are techniques that allow you to transfer tax money to untaxed money. It is very cool situations, cool schemes, legal schemes, what you can do actually legally, and to magically transform taxable money to non-taxable money. But the question actually was, does it mean that I no longer need to prepare an estate plan? No, it does not at all. If you have any type of real property, any property that's worth more than 160,000, you have to have an estate plan. You have to have a trust, because otherwise everything goes where? You know that everything goes to probate court, where we're stuck, where we pay a lot of money to attorneys. I'm happy about it. I don't want it. I want you to be safe. I want your family to be a family when sad part happens. Actually, just yesterday I had clients at my office. We prepared a plan for a couple, and the husband was already sick, and eventually he passed away. And he was very strong-willed about his wishes. And the family, it was blended family, so there were children from prior relationship for both the husband and wife. And these people came to my office. I mean, it was sad. It is a sad situation. He passed, but everyone is at peace. Everybody knows what's going on and what's going to happen. And that's the bottom line, peace of mind. We're going for the break and we'll be back.
Տարիների ընթացքում ձեռք եք բերում սեփականություն, կուտակում եք մեծ գումարներ, իսկ մտածել եք, թե ինչ է լինելու դրանց հետ ապագայում։ Լավագույն որակավորում ունեցող իրավաբան Մարիա Պրիմուշկոն իր բազմամյա հաջողակ փորձով կօգնի ձեզ ժառանգության փոխանցման, կտակ կազմելու եւ ձեր ունեցվածքն ապահով պահելու հարցում։ Estate planning, bankruptcy, personal injury եւ այլ իրավական հարցերով դիմեք MVP Law Group։ Ձեր ընտանիքի ապագան կախված է այսօրվա կայացրած որոշումից։ 818 788 7881
So, we were talking about what? About peace of mind. Everything I'm talking about, all the documents that I'm encouraging you to prepare is for your peace of mind, knowing that you're protected and your family in the future is protected. So this family came to my office in peace. They knew exactly what's going to happen. They know where to go. They know what to do. They don't have to rush anywhere. They don't have to look for a probate attorney. It will take us maybe a couple of months to decide everything, to deal with everything with his estate, for what he has to do now. So everybody knows. I gave them just direct instructions, what to do. If they need my help, they will ask for it. But usually with trust administration, there is trust, and only first spouse passes, it is very simple process. Nothing extra has to be done. And only if they just don't want to do anything, they may hire someone. Okay, we have a live call. Just a second. Good evening, MVP Law Group show. Maria Primushka is listening. How are you?
Good. How are you?
I'm doing well, thank you. What is your question, sir?
Hi. How can I convince my parents to prepare an estate planning? Because they are saying that only rich people do that. But as I'm watching your show, I'm trying to get the understanding of the subject. How would you explain that to them if you were me?
Of course. What is your name?
Logan.
Logan. All right, Logan. Thank you so much for the call. Very good question. I deal with this question very often, especially in our communities, especially with our mentality of people who came from former USSR, older generation. It is hard. We don't want to, there's some agenda. We don't want to jinx it. The idea is that if we prepare the plan, then something's going to actually happen to us, or only rich people will, only rich people need it, as Logan just told us. But it's not actually the facts. What I always recommend to my clients like that, or usually it's kids, when I talk to older people, especially sometimes, most often it's a man in power, knowing what has to be done, knowing better than anybody else, is actually giving them the power, explaining, say, hey, father or grandfather or mom, dad, as things stand now, if something happens to you, here's what's going to happen to us. Here's what I am, your son, will have to go through to receive the inheritance. This house you've been working for all your life, hard life of an immigrant usually. You worked hard. You made it here. Thank you for that. Now you have this house. You told me that you want me to have it. But without you actually put it in writing, your son, Logan, will have to go through all these hoops, pay all this money, wait for all of this time until I actually can receive it and enjoy. So your legacy will be lost. It is your legacy. You came to this country, or you just worked hard all of your life. You were able to make it happen here. You earned this house, and now it is your legacy. It's what you've created to pass on a future generation, which is me and possibly grandchildren. So is that what you want? And usually with some hesitation, unless there's sometimes already mental issues going on and people just very stubborn, usually they ease up to this. Usually they understand that what they actually want from their children. But when you explain them in simple terms, like to a 5-year-old, if you say, "Hey, mom, dad, you need to sign living trust, sign here and here," of course they're gonna be scared, they uncertain. But when I actually go, usually I draw, the picture. I explain what goes where. I explain the process thoroughly. And usually they decide that, yes, that's what we want to do. We want to protect our kids. We want to make sure that if we're at the hospital, my kid can take care of me. My child can make medical decisions. My child can transport me from one hospital to another if they decide to do so. Actually, I'm dealing with the situation right now. I receive a phone call 6 a.m. in the morning, Facebook phone call through Messenger, saying, "Hey, Maria, emergency. My mom's at the hospital, 80-some-year-old lady, and they're not doing the right procedures." Because I'm doctor, I know. I need to take my mom from this hospital to another facility, and they're not releasing her. What can I do? Unfortunately, nothing. Almost nothing, because no documents were created on time. And especially for older people, it's so important to have these documents. Like power of attorney, healthcare directive, HIPAA form, the subject we spoke about a lot. Also, for older people, Logan, you can tell your parents that if they ever become eligible for Medi-Cal and receive Medi-Cal services, if no trust is created, then their property is subject to probate. Logan will have to file a petition to probate court, and Medi-Cal will assert a lien on the house. I'm sure that's not the intention, and if you explain it in simple terms, basically, na palcach, in simple terms, what's going to happen, they will understand, hopefully. It doesn't happen all the time, but like 85% of the time with older generation, I can deal with them. Very good question, appreciate it. Next question is, Nathan Schumann asked the question, hiring an estate planning attorney is very expensive. Can I prepare my own will and figure out a plan all by myself? Well, of course you can. You can do anything. Not for everything you need an attorney. For an estate planning, you don't necessarily need an attorney. I don't know, you can do almost everything yourself, but there's always the price to pay. So you get usually what you pay for. I get a lot of resentment sometimes that my prices are high. I'm going to tell you that I'm not the cheapest attorney because I know a lot and I cherish what I've done. I'm an immigrant myself. I made a hard work here. I came here pregnant, having a baby, working as a nanny, as a housekeeper, as a property manager, and I made my way up by obtaining education, knowledge, practice, and experience. So I am not the cheapest, but I'm not the most expensive. I'm trying to tailor my practice to middle-class clients in order to protect them. But you don't have to hire me. Remember, purpose of this program is giving you information. So I'm giving you information and you decide what you're going to go. If you're going to do your own plan, that's okay. We'll see if it works. I'm reviewing sometimes plans designed by CPAs, paralegals, LegalZoom, any other software programs, and let me tell you, very few of them work because the good plan has to be done correctly and not only create it, fill in the blanks. When I create the plan, I look at your particular situation. Any good attorney looks at your particular situation, looks what your family needs. It is very rare when it is simple plan that you need. Very rare situations. It happens, and price depends on it. So it is not. Let me tell you, it's not expensive. If you weigh on a scale what you can lose without the plan and the amount that you have to pay, usually there is no question, because during the probate process, if you don't have a estate plan, 25 to 35% out of your whole estate is lost to all kinds of fees. Court fees, attorney's fees, CPA, appraisals, accountants, court-appointed personnel, publications, you name it. Just to file the probate, just to open the case is more than around $1,500. Publication, usually over $700. So you count up, it's already two something $1,000 just in fees, and you didn't pay anybody yet. And court will obligate you to pay all the statutory fees to the attorneys. Let me give you an example. Me as an attorney, I make a certain amount, I charge for trust preparation, and I get around almost 5-10% out of the whole estate. Okay, so I'm good. I make much more money. I don't like it. I don't want it. I want you to create your plan and be safe, and being protected, and no need to hurry. So when people come and complain about my prices, I usually give them the card and say, okay, so either go and please prepare the plan elsewhere, or just give this card to your kids. When time comes, let them hire me as a probate attorney. I'm okay with it. But believe me, it's worth it. Whoever you choose, but choose the right professional. You won't regret it. Okay. Konstantin Parkov asked the question, can you tell me about the gift tax and its filing requirement? I'm not sure if it's a proper program for gift tax issues, but this question comes up. So let me tell you briefly. Gift tax is whenever one person gives a gift with nothing in return, then government wants tax on it, as usual. They want taxes on everything. So usually it is the grantor who gave the gift. Let's say parent to the child. Parent gives a child $100,000. So parent has to report this gift to the IRS, saying, hey, I gave a gift to my child, $100,000. And but it doesn't mean that it's going to be taxed, because there is exemption, still that 11.5 million. So everything, all the gifts, they go towards your estate tax exemption. So and every year you are allowed to gift. Last year it used to be $15,000. Starting this year, it's $16,000 free of tax free. So you can give, if you need to reduce your estate, if you don't need so much money, or you're just very generous this year, you can give all your kids, all your grandkids, $16,000 each, and this gift will not be taxed. You don't have to report it. Anything higher has to be reported to the IRS, and a special Form 706, I believe, has to be filed with IRS, but talk to your accountant for that, please. Well, so we've just touched the surface, with all the questions that I receive almost every day. And I'll be looking forward to seeing you in the future. Please email us, call my office. Please repost this program on Instagram, on any social media. Our Instagram address, very simple, MVP Law LA. And so more and more people can find out about these issues and have peace of mind for the future. Have a good evening. MVP Law Group with you. Bye.
Տարիների ընթացքում ձեռք եք բերում սեփականություն, կուտակում եք մեծ գումարներ, իսկ մտածել եք, թե ինչ է լինելու դրանց հետ ապագայում։ Լավագույն որակավորում ունեցող իրավաբան Մարիա Պրիմուշկոն իր բազմամյա հաջողակ փորձով կօգնի ձեզ ժառանգության փոխանցման, կտակ կազմելու եւ ձեր ունեցվածքն ապահով պահելու հարցում։ Estate planning, bankruptcy, personal injury եւ այլ իրավական հարցերով դիմեք MVP Law Group։ Ձեր ընտանիքի ապագան կախված է այսօրվա կայացրած որոշումից։ 818 788 7881